Good afternoon. This afternoon we are delighted to have Danielle Bounds, who's been an absolute stalwart of our industry for some time now. Danielle has spearheaded the delivery of Martyn's Law on behalf of our industry and made sure our industry had a voice throughout the whole of the journey. So I'm delighted to get an update from Danielle of where we are now as it's come through Westminster or the paths of law. Good afternoon, Danielle. How are you?
Good afternoon, Jackie. I'm really well, thank you. And thank you very much for this opportunity.
Well, I know you've got a lot to share with us and you've prepared a presentation to help us navigate this part because it's quite a complex topic, isn't it?
It is, and it has been going through its timeline for such a long time now that I think the presentation will just help give some clarity in terms of where we've come from, where we are, and the next steps that will be coming for us. Okay, so during the course of this presentation, I am going to review Martyn's Law, that timeline we've just spoken about, give a bit of an update in terms of ICC Wales as a case study, and then Jackie will share some questions. So moving on to the first slide here. So the case for legislation. So since March 2017, security services and law enforcement agencies have disrupted 43 late-stage plots, 15 domestic terror attacks, and our current threat level from terrorism is substantial. Now, if in our industry we use the word substantial, it's something that we all sit up and take note of. So just looking at some of these numbers here actually shows why this is so important to us as an industry. There's been external commitments, government support, and campaigns from those behind Martyn's Law, namely Figan Murray, the mother of Martyn Het, who was tragically killed in Manchester. There's also been numerous inquest recommendations as well. So any bedtime reading, if anybody wants to pick that up, reading the Manchester Arena Inquiry was actually a really difficult read, but really kind of interesting in terms of how we've got to where we are and why it's so crucial that we take some action. Also, the Prevention of Future Deaths report. So that came out of London Bridge and the Borough Market inquests. So this is how we've got to this point today. It's to avoid disruption, it's to protect against a terror attack, and to also make sure that all of our delegates and visitors to our venues and our destinations remain safe. So what does that timeline look like? So back in 2019, the Conservative Party created a commitment to support Martyn's Law and take this forward. Moving on then into 2021, there was a protect duty, as it was called at that time, consultation. The government's response was published. The wonderful Queen committed to it in her speech in May 2022, and then policy and proposals were published. May 2023 was a really scary time when that first draft bill was published. And really, this is where it cemented the reason that I wanted to be involved in this. We hadn't long come out of COVID. Delivering and operating businesses and running events was really difficult with the guidelines that the government had put in. And seeing this bill and seeing the damage that it could potentially do to our industry was really important to me. We needed events to continue, but we needed them to continue safely. And that's when we provided some scrutiny into government in terms of what that looked like. We wanted everybody to be safe. This Martyn's Law was absolutely crucial, but it had to be done in the right way and actually information submitted by people from our industry. So that pre-legislative scrutiny happened in June, July 2023. During this period, we also set up a Martyn's Law working group with various different people from our industry to all talk about what we felt was important, how things should be managed in order to provide that very important scrutiny. Moving then into 2023, at the end of the year, it was reaffirmed in the King's speech. So further clarification and further commitment that this was being taken seriously. In February 23, there was the full consultation, and then in September 24, the Protection of Premises Bill first was read in the House of Commons. Moving on from that period, we then went into the first reading in the House of Lords at the back end of last year, and then April 2025, Martyn's Law received its royal assent 8 years on from the anniversary of the Manchester Arena attack. So what does the Act do? So the Terrorism or the Protection of Premises Act 2025 will be commonly referred to as Martyn's Law, and it is intended to improve protective security and organisational preparedness across the UK. As I said earlier, it's keeping our visitors, our delegates, our staff safe and make sure that everybody can go home at night. How is that going to happen? So there are various different elements and also some real important areas to focus on. So firstly, this will help ensure consistency of approach and clarity of responsibility. Within any industry, there are people that will do the bare minimum to get through. There are people who have excellent and best practice. This will help clarify that and make sure everybody is fully responsible in terms of what is expected of them and how they need to operate. It will strike the right balance. One of the most important things at that draft bill stage was urging people not to rush out and spend huge amounts of money putting in place Martyn's Law experts, because lots of people were claiming to be them, and also ensuring that any actions taken were proportionate to the threat level or to the risk. Everything needs to be looked at in a case-by-case basis, and this will help strike the right balance. There are two tiers within the Martyn's Law summary, and that is a standard duty and an enhanced duty or qualifying premises. And I'll go on to confirm a little bit about those as we speak. It's also had a regulator announced, which was something that we've only seen at the start of this year. So the regulator will be the SIA, the Security Industry Authority, and they will provide oversight, advice and inspection, and also deal with any non-compliance. So what does that standard tier look like? So the definition of a standard tier is qualifying premises where 200 to 799 individuals may be present at the same time. So what you need to do in those cases, you have to notify the regulator, and that is the SIA, and advise them of the event and the individuals that will be in that premise. There has to be appropriate public protection procedures to reduce the risk of harm if there was an attack to occur. For example, locking doors, closing shutters, and identifying safe routes. And some of these and some industries and destinations and venues do this really, really well. But it's the paper trail and the audit trail behind that to know that you've got those processes in place and know that you're doing what you need to do to keep those people safe. I'll come back and pick up on in a moment notifying the regulator of events, and just some concerns that I have as a industry professional and how that will play out. But I'm just going to move on to the enhanced tier. So the definition of an enhanced tier: qualifying premises and events where 800 plus individuals may be present at the same time. And there are some answers that need to come out from the Home Office when this information is filtered out, because what does that look like in a large scale venue? Is it just if your event reaches over 800, or what about if you're adding multiple events together and they're occupying one venue? Do you then automatically fall into that enhanced tier, and where does that venue sit in relation to that guideline? So once again, in an enhanced tier, you have to notify the regulator. You have to ensure that there's appropriate public protection, as we've just mentioned in that standard tier. The differences that you see here for this enhanced tier are the appropriate measures to reduce the vulnerability of premises or an event, an act of terrorism occurring. So, for example, at ICC Wales and in lots of other venues, they're currently reviewing and completing a vulnerability assessment to look at their building and their vulnerabilities and what they can do to overcome them. You have to measure the risk of physical harm to individuals if an attack was to occur, and that is training within a venue. And example measures around that are CCTV, bag searches, and vehicle checks. And there also has to be a fully robust public protection procedure and policies in place. And that has to be shown to the SIA and those documents kept within the venue to say that that has been investigated. So the role of the regulator, primarily, they're there for advice and to ensure compliance. And they're there to ensure that the responsible person in each qualifying premises will meet their obligations. And there's further training that will need to happen for the nominated responsible person within each venue. They will determine what is reasonably practical and what measures should be put in place, and they will work very closely with the Home Office on the law that is published and how it's implemented. And there will be joint outreach and engagement with stakeholders as this is rolled out. Just to note, and I mentioned this earlier, that they have no endorsement for third-party products or providers that claim that they can ensure they can help them to comply with Martyn's Law. So please avoid rushing out and enlisting the help of non-regulated people in order to support on this. So what does the implementation period look like? So this is 24 months, and I recently sat on a panel with the Home Office on this, and they were urging organisers not to worry about it. There's an implementation period of 24 months. However, I feel that there's a little bit of an ignorance in terms of our lead times in our industry. Yes, things are very much still short leads, but we have events in the calendar at ICC Wales that extend out to 2034 and beyond. So organisers really need to start planning and understanding that events are being contracted so much further in advance, and this will form part of any plan around that particular event that needs to happen. So within this implementation period, everyone needs to understand their obligations and plan and prepare appropriately. The Home Office will publish statutory guidance for the public to understand how they will meet that, and that will be available on the Protect UK website. So a very handy and useful area to visit with complementary downloadable assets that can be used by organisers and those venues and destinations alike. And then there will be operational guidance that will come out from the SIA about how it will discharge its duties also. So what does this look like for ICC Wales? So this is a bit of a case study in terms of this particular venue. So the ICC Wales was a newly built venue, so absolutely fantastic in terms of its access and its CCTV coverage. But I understand that not all venues across the UK were built in this way, and many have varying different factors depending on location or age of the building that need to be considered. So the staff within ICC Wales, they have already completed the vulnerability assessment. They're just about to look at their second. All of the staff have had counter-terrorism training, and they have utilised the assets on the Protect UK website. There is also a toolkit for organisers on the ICC Wales website. They are now looking at all of the properties within their area and the training that will need to happen for that responsible person, and any additional training after this SIA have discharged their duties.
First of all, thank you very much. You made it very easy to understand, although it's really huge, isn't it?
It is, yeah, absolutely. And I think one of the big kind of misconceptions with this, because the Manchester Arena attack happened in an arena and at a concert, I think, you know, one of those huge misconceptions is that it's not going to apply to us. We have business events and we host conferences and corporate meetings and association events, and a lot of people still don't realise that it will affect them. It's not just those large scale venues, and it's not just concerts. So super important that we realise that.
Mm-hmm. I'm looking at it. I'm going to look at it from a slightly different angle here. I feel that everything has been covered very, very, very well and comprehensively for the venues. However, from a buyer's perspective, because most of my work is dealing with buyers, be they agents trying to help them or the direct buyers when they're buying. So I'd like to guide them a little bit, if you don't mind. Firstly, in the world that we're in, we never thought we would be here, where we're hearing major headlines from all around the world with certain threats happening across. So in some respects, this is the right time in the current world for something like this to happen. And whilst you're saying 24 months, it couldn't come quick enough for me, in my eyes, about ensuring that the UK is as safe as it could possibly be. And you mentioned very, very well about it's not just for the venue and the people who are attending, but also for the staff that are working in there. And often those are the people who are left behind, but the staff that are also working on behalf of the buyers who are delivering those events. So these are the sorts of things that are going through my mind. So first of all, one of the things that struck me there was that whilst my event might be 199 people, so I'm sitting back thinking there's not a problem, but the venue's responsibility is far more than that. So it could be every single meeting room inhabited and every single bedroom inhabited. So therefore, it wouldn't take them very long to be certainly at the minimum level, if not going into the enhanced level in my eyes. So therefore, as a buyer, what should I be asking for from a venue, even just in the selection process? Is there something we can be asking for early doors, or understanding the process, or where do we begin? I'm sorry, it's that vague.
No, I think that's a really good question, because actually, especially knowing some of the shorter lead times, at what point would you flip over potentially from being a standard tier to an enhanced tier? And then where does the additional responsibility lie? Because we all know, running events, that actually an organizer has very little time and is very time pressured in the lead up to delivering an event. So to receive a call then perhaps from the venue that's telling them they've taken another booking and moved into enhanced tier, and there's additional requirements that they then need to deliver. How is that managed, and how is that additional work or additional costs factored in? So I think it's, this is a time of relationships more than anything, and partnerships with venues. So organisers have to be upfront, and they have to ask those honest conversations in terms of the capacities, what the process is between standard and enhanced tier, and when does that kick in? Who is then responsible? Is there a cut-off that a venue, for example, would stop taking bookings? Because I mentioned it a little bit earlier, but if we're having to notify the regulator that an event is happening, how long does that paper trail take? So, for example, if you have to log on and register the event, how often is that inbox being measured? How long before you get that back? And will that actually mean it's the death of short meetings, because we can't physically turn that paper trail around with the SIA? So I think there's got to be some SLAs to the SIA, where
we all love a
that's
good
looked
SLA.
at.
Yeah,
Absolutely. And I think, that's a really good question, and it's one that does need to be explored. And, people within our industry that are aware of that need to push back and form part of that discussion.
So as a buyer, like an agency buyer or a corporate buyer, looking at venues for where their event is going to be over, say, 200 people, which I'm a bit surprised about, to be honest. I wasn't expecting it to be so low. So could they ask for an accreditation or a document prior when they're considering the venue to understand their process, and so that it can be sent out with the proposal for the venue, so that the client has the option to judge their readiness in the event of this as part of their decision-making process as to whether that's the right venue for their event?
And that, Jackie, that's my utopia, having a Martyn's Law accreditation that shows that the venue is prepared and that they have the answers to the questions, they've done their due diligence. So it's something that we need to wait and see whether the SIA implement. I hope that it doesn't become as fuzzy as sustainability, for example, where there's no official accreditation. There are
Yeah.
various different accreditations across our industry, and how do you benchmark them against each other? It's such a grey area for
Yeah.
organisers and for clients and agents.
Yeah. So the thing is, you hit the nail on the head there and said, well, compliance with regard to sustainability is that is fuzzy. You're absolutely right, but this is law. So therefore, who could be penalised? Who could be charged with an illegal situation? Is it the organiser or is it the venue?
So it hasn't been confirmed, but indications at the moment point towards it being the venue. But dependent on the nature of the problem and how it happens and how it's managed, there will be a full inquest and an audit into it. And there are huge financial penalties that the SIA have the power to put onto those, the venues and things. So for me, it's making sure that everybody can sleep at night and have that clean conscience. So as an organizer, I would be asking, and it's in our industry at the moment, there's lots of questions that venues ask of organisers in the lead up to an event. We want your rooming list, we want your billing instructions, we want to understand your agenda, who's coming, we want to know your branding. And I think actually there needs to be a bit of a table turn here, and agents and clients need to be interrogating the venue in terms of what information they need. Have they completed all of the necessary requirements? What is their plan if there is a terror attack? How do they deal with an INVAC? How do they deal with an exvac? What does that look like? So I think, it does need to be a partnership. And I mentioned this earlier, and I think this is where relationships are key, because it's so important that you can have those honest conversations between, venues, destinations and organisers.
I'm going to step again out of the line here, because as a director of a company, I have a responsibility that I could be charged with corporate manslaughter as a personal kind of effect on my role. Could this also then go further down into an event planner? And I mean, this is, to me, this is hugely serious, and often as event planners, we're responsible for stuff, but sometimes we're the least qualified to do so, especially things like where we're managing food allergies and sharing that piece of information, etc. So this is a step further of making the profession of an event planner into much more responsible and legally required to have certain elements within their job role. Can it be assured against? I don't think corporate manslaughter can, but I'm just lost for words, because I'm not sure where we're all going to fit on this. I genuinely hope. It is a big responsibility, and sometimes the event professionals are in that position without realising that they have that responsibility. So will that become clear, do you think?
It will. And I think even more importantly, so I think the client has a responsibility to ensure everything is communicated and the questions are asked of venues and destinations. And then also the venues need to understand their responsibility. So they will have to nominate a competent person as the official terminology, and that is a qualification in counter-terrorism, and that should be supervisors and managers within businesses, and that needs to be rolled out very, very quickly, because as another bone of contention is that we really struggle to get people to come into the hospitality industry.
Exactly,
there is a huge skills shortage of people wanting to come into venues and seeing it as a long-term career opportunity. It's known to be very transient, and we don't want this huge responsibility to stop people coming into our industry as well.
So would you envisage, Danielle, so say for instance you've got a venue that has, and it's not an unusual situation, say a main room will take 200 people, theatre style, they've got 10 small meeting rooms, and they've got 10 to 15 people in having a training course for 5 days. I'm the organiser, I'm thinking, grand, no problem at all, we're well under the limit, I don't need to ask the question. So whose responsibility should that be? Should that be the venues to say, Jacqui, you're now within the realms of Martyn's law because of the capacity of this venue? You're going to have to do this. So is it all down to the venue? Because again, there's training and development within the venues as well, and that is a kind of a big move as well. Again, from the perspective of getting the right people in the right place they might be brilliant at delivering events, but paperwork is often kind of an extra chore.
If I was a client and I was booking an event at a venue, or I was an agency in charge of that, I would, to cover myself, I would put in writing to the venue, please can you ensure you adhere to Martyn's law and let me know if we're going to reach the threshold to move into the enhanced tier, and I would do that from the off. The client shouldn't then be responsible for checking in with the venue on, daily, weekly, monthly, and diaries change so much, so it shouldn't be their responsibility to keep checking in, but they needed to have had that conversation to say, will you update me if this changes?
Yeah, so do you ever envisage that by virtue of a venue trading at those sort of occupancy levels, there would be a standard process that they would be sharing this information on a daily, hourly basis with the regulators, and in which case is there going to become information overload?
And then a delay on response times for approval.
I didn't expect this as much as it is, and I'm glad in a way that we're having this conversation now. Has the 24 months started then?
Yes, so that started back coming into May. So we're a month and a bit in, and I haven't seen anything else come out as yet. But I know that there is a team working on it in the Home Office behind the scenes, and a huge amount of work will have to happen.
Great. Well, one of the great things about the UK, and it has been identified over and over again, it is a great place for professional delivery of events. We've seen that when we jumped in to do the Eurovision. We've seen that with every step along the way of what's been delivered. I know we can lead the way on this, but what about internationally? Are other countries taking this on, or are we the only ones?
There's a lot of discussions happening internationally, and I actually spoke about this at an international event, and most of the people that came up to me afterwards were from various countries from around the world that were saying, we have these same challenges, we have these same concerns, this is absolutely crucial to us, how can we help, how can we support, please can you share your documentation? And that there are venues all around the world that are trying to implement this best practice, even in the absence of some of the government support in those countries. And interestingly, Vegan has also flown around the world as well to talk about this. So it's something that affects us all. And the UK are very fortunate in terms of the process it's gone through and the support the government has given it. But it's something that needs to be taken on by the rest of the world as well.
There is that comment that's in my mind, is that why was it not already part and parcel of what we've done, because that's what we all expect. We expect to be able to go into a concert hall or an event space and be safe, and rightly so. But certainly it is good to see it happening. However, it'll end up, because certainly, as I mentioned there, a little bit more questions than answers in some respects, but that's no bad thing because we're on a journey together. But I would say in the world we're in, we cannot wait 24 months. We've got to make this happen as soon as we can to make the UK into the safe place. And we all have a part to play by the sounds of it too, which I don't think is a bad thing. I don't think it's a bad thing. But is there anything else you would like to add?
No, I think we've covered pretty much everything, but I'm really grateful of the opportunity to talk about it again, because the more people that hear about this, the more people then that will start asking questions, and the safer everything will be.
Well, thank you very much indeed, Danielle, and look forward to catching up with you again very, very soon, and hearing the next installment of this this journey that you
This labour of love
are on. It is indeed. Thank you very much. Bye-bye now.
Thank you.